Thank you everyone for making it today on a Friday evening. This policy brief has been really the labor of the last 1 year that we've been working on. And really the impetus for this work came from many activists from the trans movement, especially Grace, who's here with us today. And this has been the effort of our team at CLPR, so it gives me great pleasure to take you all through some of the most salient features of the policy. My idea in this presentation, since all of you don't have the policy brief yet, is to take you through some of our findings and recommendations, and then the brief will be available after the launch. The impetus for the question of reservation came from the decision of the Supreme Court in Nalsa versus Union of India. This was a decision passed by the Supreme Court in 2014. This was the first ever decision where the question of constitutional rights of transgender persons went to court. In this case, the Supreme Court, for the first time, held that transgender persons have the constitutional right to self-identify their gender as either male, female, or transgender. So the court, it's quite a path-breaking decision, not just for the transgender community, but on gender, generally. The court held that our guarantee of non-discrimination under Article 15 of the Constitution, Article 15 guarantees that there shall be no discrimination on the basis of sex, caste, place of birth, or any other such categories. And the court held in the Nalsa decision that sex under Article 15 would also include gender and gender identity, and held that any discrimination on the basis of gender identity would also fall under the discrimination on the basis of sex. Therefore, for the first time, recognizing that any discrimination against transgender persons on the basis of their gender would be a form of sex discrimination. And in fact, this is, the interpretation that has been carried on even in the recent Section 377 decision. The court went on to hold that transgender persons have the constitutional right to self-identify themselves as either male, female, or transgender, and this is even without transgender persons having to undergo any kind of medical reassignment or take any other hormonal or medical treatment. It went on to further say that since trans persons have been discriminated, they should be given rights under special provisions of the Constitution, and held that they should be treated as socially and educationally backward classes. Now, this is what we want to explore in this policy brief. The court, actually the actual direction of the Supreme Court was that the center and state governments should take steps to treat them, that is, treat transgender and intersex persons as socially and educationally backward classes of citizens, and extend all kinds of reservations in case of admission in educational institutions and for public appointments. So this was the first time that the court kind of gave such a direction. Now, after this direction was given in 2014, nothing has happened. Reservations have not been provided by the center and state, and there have been a few cases where there's been confusion about how to provide reservations, and that was really the impetus for our policy brief. Now, we divide the policy brief into three main sections. So the first section, or the first issue we really address, is that if reservation has to be provided to transgender intersex persons, there has to be clarity as to who the beneficiaries are. So there's to be clarity on definitions. There is presently, apart from the transgender movement, I think even for the court and for the government and socially, I think there is no clarity as to what is really a proper definition for transgender and intersex persons, and any reservation policy will need to address that. So we studied this issue a little more carefully, and we looked at how the definitions for transgender and intersex persons have been evolving. So, Nalsa, the Supreme Court in the Nalsa decision, used the umbrella term of transgender. transgender was used as a broad umbrella term to take into account many different gender minorities. And a very broad definition was given. There was thereafter a 2014 bill introduced. This was called the Transgender Persons Bill that was introduced in 2014. It was a private member's bill introduced by the MP Tiruchi Shiva. And this was actually one of the first draft legislations for protection of rights of trans people. And this bill defined transgender persons broadly as any person whose gender identity does not match their sex assigned at birth. Of course, it elaborated it a bit, but this was broadly the definition given. There was one serious flaw with that definition. It did not specify or include intersex persons. Then came the 2016 bill. There was a draft that was made or prepared by the ministry, the central government, and the 2016 draft was a completely different draft from the 2014 bill for the transgender persons' protection of rights. There was a definition of transgender that was a much broader definition but was highly problematic, and that was completely rejected by the trans community. And now finally, as some of you may have read, a few days back, there was a 2018 bill introduced in the Lok Sabha. And this was introduced, I think, on 17th of December. So it was just a few days ago. And the 2018 bill is virtually, very much like the 2016 bill with a few amendments. One of the amendments was made to the definition, and I've reproduced the definition of transgender and intersex persons. The 2018 bill defines transgender person as a person whose gender identity does not match with the gender assigned to that person at birth and includes a trans man or a trans woman, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy or such other therapy, persons with intersex variations, gender queer, and persons having such socio-cultural identities as Kinnar, Aravani, and Jogtas. So, what we see in the 2018 bill is that there is again an umbrella term of transgender person provided. One improvement made due to the inputs made by the trans community is that the inclusion of person with intersex variations was included. And therefore, this is the definition used. But what we see in the Indian context is that there is just an umbrella term of transgender persons used. There are no separate terms for transgender persons and intersex persons. And internationally, this is not seen as one category. Internationally, if you look at international treaties and practices in other countries, transgender and intersex persons are seen as separate categories and also recognized separately. So if we move on, the definition that we recommend, which we have borrowed from other sources, is that, of course, we retain the definition of transgender persons that has been used, but we also recommend that intersex persons should also be given an adequate and separate definition. And the definition used by the UN, by the Office of the UN High Commissioner for Human Rights, and this is largely definitions that are used in other jurisdictions as well, which defines intersex persons as persons born with sexual anatomy, reproductive organs, or chromosome patterns that do not fit the typical definition of male or female. This may be apparent at birth or become so later in life. An intersex person may identify as male, female, or neither. Why do we want these different definitions? So that the law, whichever law is introduced, or courts recognize that intersex persons and transgender persons are not the same, and therefore the need for clarity in these definitions. If there is clarity in definitions of who the beneficiaries are, then before we get on to reservation, there's to be a way for legal recognition of transgender and intersex persons. And what is the mechanism for such legal recognition? Now, what the Supreme Court held in Nalsa The Supreme Court only held that yes, your gender, you have a right to self-identify your gender as male, female, or transgender. I mean, you may be born with the sex female, but you may identify yourself as male. If you identify yourself as male, you should be able to get legal recognition of that gender identity. But the court didn't say how you can get that legal recognition. Today, we have a situation where many trans and intersex persons want to change their gender identity in their documents, in their legal documents, in their educational documents, but there is no clear process as to how they can do it. So NALSA guaranteed the constitutional right that each person's self-identified sexual orientation and gender identity is integral to their personality and is one of the most basic aspects of self-determination, dignity, and freedom, and no one shall be forced to undergo medical procedures, including SRS, sterilization, or hormonal therapy, as a requirement for legal recognition of their gender identity. So it said that you could decide your gender identity without any medical intervention. And this is actually the standard even, if you look at broad human rights standards. We looked at various, professional bodies. There is the World Professional Association on Transgender Health. It's one of the most well-recognized bodies the world over, which in fact say that there should be no medical health assessments if a person wants to recognize their gender identity. And medical requirements would include counseling, therapy, puberty blockers, hormonal treatment, or any kind of surgery, or even letters from doctors. And gender identification processes should be completely demedicalized. And many countries have followed that in their laws. Even today, despite the Supreme Court holding that, in our own experience, when we take up cases, we have filed several cases in the High Court seeking change of documents for transgender persons. And even judges, who have read NALSA, ask for medical reassignment certificates. They ask for doctors' letters. They ask for mental health assessments, that you have to show that you have gender dysphoria. Only when medical documentation is provided do even courts agree that your gender identity should be changed in your legal documents. Yeah. So what we recommend in our policy brief is that gender recognition procedures should be quick, accessible, and should only be based on self-identification declarations as an affidavit. You should not have any requirement of medical requirements. One should be able to get gender recognition as male, female, or transgender, or in some cases other. There are different state policies. Many states have their own transgender rights policies, but they all have different procedures. Some states have self-identification methods. Some states ask for medical documentation. And some states don't have policies, but they have transgender welfare boards. And these transgender welfare boards are granting gender identification documents or ID cards. The big issue is that if you have a transgender welfare board, there should be adequate representation on these boards from the trans community to ensure that the identification is given only based on self-identification and not by insisting on medical documents. And finally, we get to the core of the policy brief. How should, once the definition and the self-identification process is clarified, how should the reservations themselves be implemented? This is a slightly more technical and legal part of the policy brief, but I think it's important that this is that we go through it. So constitutionally, our constitution provides for reservations, and the categories for whom reservations are provided are on the basis of caste and gender and some other categories. So our reservations are provided under the Constitution under Articles 15 and 16. And just to give you all a brief overview, in one of the landmark decisions of Indra Sawhney versus Union of India, which really kind of elaborated on reservations, what the court held is that there are two kinds of reservations. There are vertical reservations and horizontal reservations. And we've drawn a simple chart. So vertical reservations were under Articles 15.4 and 16.4, which are on the basis of social categories of caste, mainly caste, OBC, that is other backward classes, and socially and educationally backward classes. So these were taken as vertical categories. So you would have SC, ST, scheduled caste, scheduled tribes, OBCs. And then NALSA, I will get to the horizontal categories a little later. NALSA mandated that there should be reservations for transgender persons as socially and educationally backward classes. Now, if we take the guidance of the Supreme Court in the NALSA decision very strictly, this would mean that transgender and intersex persons would also get a vertical category of reservations like SC, ST, and OBC. But if we look at horizontal reservations, as mandated in the Indrasoni judgment, horizontal reservations are for categories such as under Article 15.3 and 16.1, which are for women, persons with disabilities, and many other categories. You have categories of freedom fighters, project displaced persons. So there are many additional categories put in the horizontal reservation section. These horizontal categories cut across the vertical categories and make interlocking grids. So you would have the category of reservation for women you could have SC women, you could have ST women, you could have a general open category women section, or OBC women. So if you are a woman you're a scheduled caste woman, you would have a special quota of an interlocking reservation under SC and women category. Now and then there are further elaborations of reservations being compartmentalized and overall. I'm not going to go into that. That is there in our policy brief. What we recommend is that when considering reservations for transgender and intersex persons, the reservations should be horizontal and not vertical. And why do we recommend that? We recommend that because only if there is a horizontal reservation for transgender and intersex persons, it would take into account the various different caste identities that trans persons have. This will ensure that Dalit and OBC transgender and intersex persons will not be required to give up their caste categories. If they are a vertical category instead, all their caste identities are completely invisibilized. They would just be recognized as transgender and intersex persons without any other caste identity. This would also mean, if it is vertical, that trans and intersex persons from different caste backgrounds would be placed in the same pool and would have to compete with each other, which would then mean that more marginalized caste persons would never get opportunities again. So that is what we recommend. Just a small note, there are some interesting decisions of other high courts which have also said that transgender persons who identify as women can also get reservations as women. This has especially been done by the Madras High Court in a few cases. So we also recommend that trans persons who wish to identify only as women and not take on the transgender identity, that option to avail reservations under the women category should be open. Yeah, and finally, the extent for reservations. We don't make in our brief any particular percentage that we recommend. The 2014 bill had actually included a provision of 2% of seats to be reserved for transgender intersex persons. The 2018 bill, unfortunately, does not provide for any reservations at all. Yeah. So the 2018 bill does not provide for reservations. It does not. It has many other problems. It requires, medical requirements for gender identity recognition. So all those issues are there, but most importantly, it does not provide for any reservations in education or employment, public employment for trans and intersex persons. Yeah. So finally, we conclude with a list of recommendations that we give in this policy brief, and some of them are, what we do recommend is that there should be a comprehensive central legislation this legislation should provide acceptable definitions for the category of transgender and intersex persons as we recommend. There should be provision in this law for recognition of gender identity, not just as transgender, which is what the current bill does, but as male, female, or transgender, based on self-identification and without any medical treatment. There should be committees or welfare boards that would issue identification cards, and to ensure that those committees or boards have at least 50% reservation from the transgender community. There should be a percentage for the reservation quota to be arrived at. We are not making a recommendation of any percentage, because I think that arrival at the percent, whether it should be 2% or 3%, needs more study and a little more realistic picture of the number of transgender persons as well. We do have a census which was taken, I think, in 2011, but the census, I think, was taken much before NALSA, so I'm not sure whether we can rely on that. And finally, we recommend that there should be horizontal compartmentalized reservations for transgender and intersex persons in education and public employment. So that is, those are really the core of our recommendations and our policy brief. Thank you.